You, as jurors, are the sole judges of the credibility of the witnesses and the weight their testimony deserves. You know, of course, that there is no automatic way to decide who is telling the truth and who is not. Credibility can be equated with believability and reliability. If a witness is credible, you say he is believable and reliable. If he is incredible, you say he is unbelievable. There is nothing arcane about these words. By what yardstick are you to judge the credibility of witnesses? Each of you has given careful attention to the testimony as it came from the witnesses themselves. You have observed the witnesses. Issues of fact are presented for your determination. An issue of fact is presented, for example, when one witness avers that a certain event occurred, and another witness asserts that it did not occur. To a large extent, the resolution of the disputed issues of fact depend upon the credibility which you attribute to the witness's testimony and the support or lack of support that testimony received from other evidence in the case. Your duty is to decide the disputed issues of fact. In doing so, use your logic, your reason, and your common sense. Do not be sidetracked or diverted or distracted by what you consider to be minor or insignificant nuances or irrelevancies, or by what you consider to be an appeal not to your reason or logic but to mere sentimentality or unthinking passion. I repeat, use your common sense. You should carefully scrutinize all the testimony given, both direct and cross-examination, the circumstances under which each witness has testified, and every matter in evidence which tends to show whether a witness is worthy of belief. Consider each witness's intelligence, motive, and state of mind, and demeanor and manner while on the stand. Consider the witness's ability to observe the matters as to which he has testified, and whether he impresses you as having an accurate recollection of these matters. Consider also any relation each witness may bear to either side of the case, the manner in which each witness might be affected by the verdict, and the extent to which, if at all, each witness is either supported or contradicted by other evidence in the case. Inconsistencies or discrepancies in the testimony of a witness or between the testimony of different witnesses may or may not cause the jury to discredit such testimony. Two or more persons witnessing an incident or a transaction may see or hear it differently, and innocent misrecollection, like failure of recollection, is not an uncommon experience. In weighing the effect of a discrepancy, always consider whether it pertains to a matter of importance or an unimportant nuance, and whether such discrepancy results from innocent error or intentional falsehood. In determining credibility and weight to be given to the testimony of any witness, you must judge the testimony of the government employee whose witnesses are in the same way testifying, in which you judge the testimony of any other witness. The mere fact that they are employees of the government entitles them to no more and no less consideration than any other witness. Nor should you be influenced by the number of witnesses a side has called or the number of documents received in evidence. It is the quality of the testimony and other evidence which counts, not the quantity. After making your own judgment, you will give the testimony of each witness such credibility, if any, as you may think it deserves. If you find that any witness, and this applies to all witnesses, has willfully testified falsely as to any material fact, you may reject the entire testimony of that witness, or you may accept such part or portion as commends itself to your belief, or which you may find corroborated by other evidence in the case. During the course of the trial, you have heard the testimony of a person who testified concerning the involvement in the crimes charged in the indictment. Such person is called an accomplice. Under the law, in order for one to be an accomplice, he must have been involved in the commission of the crime or crimes with which a defendant is charged. He must be a participant in that crime or crimes. Ladies and gentlemen of the jury, you have now heard all of the evidence in the case and the arguments of counsel, of course, and it now becomes the duty of the court to instruct you as to the law which you should adopt and apply to the facts as you find them to be in this case. In the trial of a jury case, such as this one, the court and the jury work as sort of a team, so to speak, the court passing upon and determining all questions of law throughout the trial, and the jury finally determining all questions of fact. And then when we reach this point in the trial of a case, it becomes the duty of the court.
A little fast.
It was, let's see, it's 1, 2, 3, 4,
According
5.
to this, it was 187. I don't know if that's right.
20. Yeah.